Congressman Chris Deluzio joined 5 other Democratic lawmakers, all of them military or intelligence community veterans, to urge current officials to disobey illegal orders. Michigan Senator Elissa Slotkin, a former CIA analyst, posted the video. The lawmakers say threats to the Constitution aren't just coming from abroad.
No one has to carry out orders that violate the law or our Constitution.
We know this is hard and that it's a difficult time to be a public servant.
But whether you're serving in the CIA,
The Army,
our Navy,
the Air Force,
your vigilance is critical.
and know that we have your back.
Because now, more than ever,
the American people need you.
We need you to stand up for our laws,
our Constitution,
and who we are as Americans. Don't give up.
Slotkin told the New York Times that she's heard from active duty troops who are concerned about the legality of strikes on people the Trump administration says are drug traffickers. The administration called the video an attempt to encourage the military to rebel against Trump.
Hi, buddies. Adam is here. So what just happened? Across multiple policy areas, courts and Congress have been systematically blocking Trump's executive overreach. Injunctions, reversals, agency backdowns, case by case, order by order. The documented record tells a story the headlines often miss. The system of checks and balances is actually holding.
A federal judge in California has ruled that the mass firings of federal employees who were in the probationary period were likely unlawful. It's our top story on the WHAS 11 Night Team. Hello, everybody. I'm Doug Proffitt. U.S. District Judge William Alsup ordering the Office of Personnel Management to admit they don't have the authority to order the firings of any other department. 5 labor unions have sued to block the Trump administration's massive dismantling of the federal workforce. They say numerous agencies informed workers that the Personnel Office had ordered the terminations with an order to use a template email informing the workers that their firing was for performance reasons. Alsup also ordered the head of the Personnel Office to testify in court about the nature of a phone call with agency heads who were told to fire probationary workers. Thousands of employees have already been fired, and the judge's ruling does not mean that they're going to be rehired or that more won't be fired.
Here is the specific documented record. A judge ruled that the mass termination directives for firing probationary federal employees were unlawful, invalid, and must be stopped and rescinded, ordering the agency to reverse course and notify all affected departments. That stopped one of the most sweeping workforce actions in federal government history in its tracks.
Breaking news now, the Supreme Court says it will hear an expedited appeal of President Trump's attempt to end birthright citizenship by executive order. The court did not explain its decision, and the case will likely be heard next spring. For more than 100 years, courts, interpreted the Constitution to give U.S. citizenship to anyone born on American soil, regardless of the legal status of the parents. Now, that may hang in the balance.
4 separate judges ruled against the executive order attempting to end birthright citizenship for children of non-citizens, with the 4th judge finding it likely unconstitutional under the 14th Amendment, leaving the order completely unenforceable across the country. A federal court blocked core provisions of the anti-voting executive order, ruling there was no authority to impose new election rules or tie federal funding to state compliance, with the judge warning that allowing a president to dictate who can vote is especially dangerous, and stating that any executive order without statutory or constitutional authority is unlawful and must be halted. A separate case found the use of active duty soldiers to police protests violated the Constitution and the Posse Comitatus Act, establishing that courts will stop attempts to use the military as a domestic police force. And on the congressional side, oversight letters demanding reversal of visa suspensions and mass terminations produced administration backdowns within days, demonstrating that congressional pressure combined with legal exposure is producing actual policy reversals rather than just political rhetoric. Birthright citizenship order unenforceable, anti-voting order blocked, mass firing directive rescinded, military domestic policing found unconstitutional. Each of those is a specific documented executive order issued by this administration, declared unlawful by federal courts, reversed or halted before it could produce its intended effect. That is the rule of law working. Courts applying constitutional and statutory limits to executive action. Congress amplifying those limits through oversight, and the combination of the two producing actual accountability for actual unlawful conduct rather than just political criticism of aggressive policy. Let me give you the full context you need to understand why the specific pattern of unlawful orders being blocked and killed across multiple different policy domains in a compressed time frame is so significant for the overall picture of whether governance by decree can actually work. The theory of the second-term executive agenda was that the president can use executive orders and emergency declarations to implement sweeping policy changes without congressional authorization, and that a conservative judiciary would provide enough legal cover to allow those changes to take effect before challenges could produce effective reversals. The documented pattern of blocked orders tells you how well that theory is working in practice. Birthright citizenship order blocked by 4 judges, including some appointed by Republican presidents, within weeks of issuance. Anti-voting order blocked at its core provisions, with the judge specifically warning that presidential dictation of voting rules is especially dangerous. Mass firing directives found unlawful and rescinded. Military domestic policing found to violate the Constitution and the Posse Comitatus Act. None of those orders produced lasting policy change. Each was stopped by a court applying specific constitutional and statutory limits that the order exceeded. And the pattern across 4 different policy domains in a compressed time frame is the documented evidence that the governance by decree theory is not working as the agenda assumed it would. The courts are enforcing constitutional and statutory limits across the range of executive overreach, not just in specific high-profile cases. Let me really dig into the full picture of what the blocked orders and congressional accountability tell us. There are 3 distinct dimensions that each deserve careful treatment. The first dimension is the specific legal basis for each blocked order. The birthright citizenship order is the most constitutionally significant of the blocked orders because it attempted to rewrite the 14th Amendment's guarantee of citizenship to all persons born on United States soil through executive action. That is a reinterpretation of a constitutional provision that can only be changed through the constitutional amendment process, not through executive order. 4 judges independently reviewing that order all reached the same conclusion. The 14th Amendment's plain text and 2 centuries of consistent interpretation as guaranteeing birthright citizenship cannot be changed by presidential decree. The unanimity of 4 judges across the political spectrum on the same constitutional question is the clearest available signal that the order exceeded constitutional limits that are not subject to executive reinterpretation. The anti-voting executive order blocking is the most democratically significant of the blocked orders because it attempted to use presidential executive authority to impose new election rules in a domain where the Constitution specifically assigns the regulation of elections to Congress and to the states, not to the executive branch. The judge's warning that allowing a president to dictate who can vote is especially dangerous is the specific constitutional characterization that makes this ruling so significant, because it identifies the specific democratic threat that the order represented. A president using executive authority to control the franchise is treated as itself a reason for heightened constitutional scrutiny. The mass firing directive ruling is the specific administrative law accountability that most directly affects the day-to-day functioning of the federal government. The mass firing of probationary federal employees was designed to rapidly reduce the federal workforce in ways that would have gutted the career civil service structure. The court's finding that the directives carrying out that mass firing were unlawful, and its order requiring reversal and notification to all affected departments, stopped one of the most operationally significant workforce transformation efforts in the administration's agenda. And the military domestic policing ruling, finding that using active duty soldiers to police protests violated the Constitution and the Posse Comitatus Act, adds the most constitutionally fundamental dimension to the pattern of blocked orders. The Posse Comitatus Act, one of the foundational statutes of American civil-military relations, specifically prohibits the use of active duty military forces for civilian law enforcement purposes except as expressly authorized. Using active duty troops to police civilian protests outside the specific Insurrection Act authorization framework is the specific violation that the court found. The congressional accountability role. The oversight letters demanding reversal of visa suspensions and mass terminations produced administration backdowns within days. That sequence, congressional letter, administration reversal, is the informal accountability mechanism working as designed. Elected officials exercising the oversight function that the Constitution assigns to Congress, and executive branch officials responding to that oversight by reversing unlawful actions rather than defending them through litigation. The speed of the reversal within days is the specific feature that reveals why the combination of congressional pressure and legal exposure is so effective. The administration did not fight through months of litigation. It reversed within days because the combination of congressional attention and clear legal exposure made the political cost of continued defiance exceed the policy benefit of maintaining the specific actions being challenged. And the legislation being introduced to permanently prevent similar unilateral orders in specific domains represents the longer-term accountability strategy that goes beyond stopping individual unlawful orders to building statutory safeguards that would prevent future administrations from attempting the same overreaches. That legislative strategy, using the documented illegality of specific executive orders as the factual basis for legislation that permanently bars similar orders, is the institutional response that converts individual accountability victories into lasting constitutional safeguards. What the overall pattern reveals. The combination of judicial review and congressional oversight is working as the constitutional design intended. Courts are applying the limits that the Constitution and federal statutes impose on executive action. Congress is using its oversight authority to amplify those limits and create political consequences for defiance. And the administration is responding to that combination by reversing unlawful actions more quickly than judicial proceedings alone could require. The system is holding. The most aggressive unlawful orders are being stopped before they can produce lasting damage. And the combination of accountability mechanisms is proving more resilient than the governance by decree strategy anticipated. The four-judge unanimity against the birthright citizenship order is the most constitutionally significant judicial accountability action in the entire blocked orders story. Four judges independently reaching the same constitutional conclusion establishes that the order is not just legally controversial, but constitutionally indefensible. A finding that closes off the appellate pathway for the order and makes its permanent unenforceability the most likely outcome of the litigation. In normal constitutional litigation, even over controversial executive actions, you typically see splits. Some judges supporting the executive's legal theory and some rejecting it. Four judges all reaching the same conclusion without a single judge finding the executive's constitutional theory viable describes a constitutional question that has already effectively been resolved at the level of lower court review. The anti-voting order blocking, with the judge's explicit warning that presidential control of voting rules is especially dangerous, is the most democratically significant judicial accountability action in the entire blocked orders story. It identifies the specific threat to democratic governance that the order represented and treats that threat as itself a basis for heightened judicial scrutiny. Courts apply heightened scrutiny to government actions that threaten fundamental constitutional rights, and the right to vote is among the most fundamental rights in the American constitutional system. The judge's explicit characterization of presidential dictation of voting rules as especially dangerous is the judicial institution's formal recognition that executive control of the franchise threatens the democratic foundation on which all other constitutional rights depend. The oversight letter reversal within days sequence is the most practically significant congressional accountability success in the entire blocked orders story. It demonstrates that congressional oversight combined with clear legal exposure produces actual policy reversals faster and more completely than litigation alone, and that the combination of oversight and litigation is the most effective available accountability mechanism for stopping unlawful executive actions before they can produce irreversible damage. Judicial proceedings, even emergency injunctions, take time. Congressional oversight letters combined with clear legal exposure can produce reversals before any judicial proceeding is necessary because the combination of congressional attention and litigation risk raises the political cost of continued defiance to a level that makes immediate reversal the administration's best available option. Here is what we need to watch as the blocked orders accountability story continues to develop. The appellate review of the birthright citizenship blocking order, and whether circuit courts and ultimately the Supreme Court affirm or overturn the four-judge unconstitutionality finding, is the most consequential pending constitutional question. A Supreme Court affirmance would permanently establish that the 14th Amendment's birthright citizenship guarantee cannot be altered through executive order. The anti-voting order litigation, and specifically whether the core provisions blocking survives appellate review, will determine whether the president retains any executive authority over federal election rules or whether that domain is definitively assigned to Congress and the states. The legislation being introduced to codify the limits that court orders are currently enforcing, and whether any of that legislation can attract the bipartisan support needed for passage, will determine whether the judicial accountability victories produce permanent statutory safeguards or remain dependent on the continued availability of court orders, and the overall trajectory of the governance by decree strategy, whether the administration adjusts its executive order approach in response to the documented pattern of blocked orders or continues issuing orders in the same overreach pattern, will determine whether the blocked orders pattern represents a temporary accountability correction or a sustained redirection of executive governance. The thing I want you to carry away from everything we covered today: 4 federal judges blocked the birthright citizenship executive order as likely unconstitutional under the 14th Amendment, leaving it completely unenforceable. A federal court blocked core provisions of the anti-voting executive order, finding no authority to impose new election rules and warning that presidential control of voting rules is especially dangerous. A court found the mass firing of probationary federal employees unlawful, ordering the directives rescinded. A court found the use of active duty soldiers to police protests violated the Constitution and the Posse Comitatus Act. And congressional pressure through oversight letters produced administration reversals on visa suspensions and mass terminations within days. The governance by decree strategy is hitting a documented wall across multiple policy domains in a pattern of judicial and congressional accountability that is stopping the most aggressive unlawful orders before they can produce lasting damage. The power is ending not in a single dramatic moment, but in the systematic enforcement of constitutional and statutory limits that courts and Congress are applying case by case, order by order, reversal by reversal.